Hello, everyone, and welcome to Notes to My Legal Self. I'm really excited to have this conversation. We're going to talk about litigation. I almost never talk about litigation on the show and focus a lot on what happens every day, career-wise, transactions, and stuff like that. But underneath it all, there's risks that we manage, and litigation is a major risk for many in-house lawyers. They have to manage on a daily basis in their contracts and their products, and yes, in litigation as well. So I'm really excited to see a lot of development in technology and see how this technology evolves. And without further ado, I have a fantastic expert and guest and CLO who is going to be joining us today. Dean, without further ado, for folks who haven't met you, please introduce yourself.
Hi, everybody. I'm Dean Whalen. I'm the Chief Legal Officer for Readback, which is a deposition service. Thank you, Olga, for having me.
Tell us a little bit more. What are you doing day to day? And how does, one get up in the morning and become who you are? What happened?
I started as a litigator like you. I was a prosecutor like you. And I also was in the general practice of law for 20 years. And in 2005, I joined a company that did court reporting. So I ultimately helped that company grow the business, and along the way became in a leadership role in a court reporting company. That company was purchased in 2017 by a tech company called Infraware. And then we developed this deposition product called Readback. That is essentially what we're going to talk about today. Not my product, but what deposition technology has turned into. So in the day of the life of me, it's about getting the word up about how important deposition technology is and how important depositions are.
Yeah, I've been very fascinated with process of litigation and how it predicts outcomes, not just legal outcomes, but business success outcomes. But before we sort of jump into that, tell me a little bit more about that transition from litigation and being a prosecutor to in-house at a legal tech company and, eventually having this technology journey. What happened? How did that opportunity happen? What is the story? Tell me a story, Dean. I would like a good story.
What happened was I really started helping a friend who owned a court reporting company. He wanted to grow it. He had a technology company that basically worked with insurance companies, law firms, doing speech to text kind of reports, et cetera. And he wanted to grow the business. So he asked me to come in. He didn't have an in-house counsel, take a look at what was going on. And also along the way, it became kind of business development, and it was fun. So I thoroughly enjoyed it. And along the way, I actually became a leader in the court reporting field. And that's a booming business. It's a $40 billion business. But I also saw all of the problems that were existing in the court reporting field.
What problems did you see, and what inspired you to sort of keep digging, keep learning more, and essentially over time pivot the trajectory of your career?
Yeah. So as a litigator, I used to do depositions, and depositions were more of a box checking event, getting the information you needed. And then when I became a leader in the court reporting industry, I kind of got a look behind the curtain. And what I saw was that over the course of a number of years, the court reporting industry really became broken, predominantly because the stenographers across the country became scarce. There's a shortage of stenographers. So as I became more and more involved in the court reporting industry, a day in the life of my job, which was basically running the court reporting department, was asking attorneys to wait longer for their transcripts because of the supply and demand issue and pay more. In today's information age, how can you ask somebody to wait longer and pay more? But that's in fact what is and continues to happen.
What is something you wish litigators or folks who manage risks of litigation, they better understood about court reporting that you couldn't really fully appreciate until you actually read it and become a subject matter expert in the area?
When you're running a company You want to avoid risks. And when some of the conversations that larger companies have with their in-house counsel and outside counsel is how to handle a discovery budget, right? How much money do you spend on depositions? I was really shocked to learn that very few attorneys use real-time depositions. And attorneys that understand what real-time deposition is immediately say, well, I don't use it because of the price tag associated with it. And I think what in-house lawyers need to know now with the advancement of technology, the advantages that you can gain using real-time deposition services are significant. And that's after speaking with, I'm going to say, over 100 litigators, from solo practitioners to the big boys. The larger firms that were using deposition services that were advanced felt like they were playing chess while others are playing checkers. And so while you want to control your discovery budgets, now technology has brought real time into a situation where the average company can afford it. And actually now the average company shouldn't live without it because of the advantages associated with it. If you take a live deposition and you have a live feed in front of you, attorneys that are using this tool can now create a transcript that is precise. Some attorneys are taking exports from that transcript and using AI to feed a project with all of the pleadings, the complaint, the experts, reports, police reports, etc., and using that and creating questions during the deposition and double checking themselves. That's when I'm talking about playing chess while others are playing checkers.
I understand the value of sort of real-time question creation as you depose someone, but I'm curious about the third actor, courts. And one of many reasons why we have stenographers and why it's a protected industry in many states by statutes. What do you do about the courts and their enforcement of statutes, which I think, at least in some states, are still on the books?
So courts often require a stenographer. And in California, there's quite a tug of war going on to make sure that if there's a shortage of stenographers, there's a number of cases that go without any record. And so what they've done is they've passed some legislation and some pilot programs to allow for the recording of the actual hearings in trials. And you're having custody cases without records. You're having some criminal trials without records. If you're going to have an appeal, you need a record. It is unconstitutional. The battle lines mainly are the steno lobby, where they're saying, no, you shouldn't have these electronic recordings because you should have a stenographer. And so they in California, they're throwing a lot of money at that, trying to cover the stenos and letting them appear remotely. In the end, a verbatim transcript is a verbatim transcript. If it's created from an electronic record, it's as accurate as the stenos can do.
There are laws in the books and powerful lobbying around this. And I know some states have made different decisions and some states have battles over it. And so I'm just curious, to what extent do you think you can overcome this?
To me, it's logic. The lobby would argue that you shouldn't allow for electronic recording. So you either have a stenographer or nothing. And there's many, many, many courts with nothing. That doesn't make any sense. Where there isn't an available stenographer, you simply record it. Then you have something, right? You can protect the record. All of the cases here in Massachusetts are recorded, down to the small claims. So the understanding that the capturing of a record, regardless of whether or not it's, quote, the gold standard record or it's an electronic record, is critically important. And most states are already well into accepting the electronic recording of these hearings.
So you alluded a couple of times to this forced closing argument. What is and what changed in litigation that made this concept necessary now? What makes it very timely today?
Yeah, I wrote that piece, The Fourth Closing Argument, because I think it's critical for all litigators and for in-house counsel to understand that if you're a litigator, there's three closing arguments that you have in a case. The one that you practice, the one that you deliver to the jury, and the one that you have in the car ride home saying, I wish I said this or I wish I said that. We've all done it. Olga, you can admit it. Now, come on now.
I talk to myself all the time. I mean,
yeah.
I'm happy to admit that I enjoy my own conversations.
Right. I've done it. And so when we're up there, we're doing our closing argument. We want to get that balance between not missing anything and creating some energy so that the jury knows we're convicted to it, et cetera. And we're going to miss some things. Here's what we know. Trials went from 1962, I think the percentage was 11.5% of cases went to trial. In 2002, it went down to 1.8. And recently, it's less than 1% of cases go to trial. So if cases aren't going to trial, so you can do those three closing arguments, practice it, deliver it, and complain about it on the car ride home, then what's the next closing argument? The next closing argument in my mind is the actual deposition itself. And you know, when you do a deposition, you're doing a deposition to prepare for summary judgment, and that's critical. All of these things can be nailed down in the deposition, but you have to do it with the use of real time, because what I was hearing from attorneys who didn't practice real time is that they get the transcript back 2 weeks later and they'd say, I thought I nailed it, but the answer isn't quite as good as I thought it was. Or they'll actually say to a client, hey, I think we did really well, but let's see how the transcript reads. I mean, in today's information age, with all due respect, we shouldn't have to do any of that. To me, it's clear as day. There was only 1% of litigators using real time because it was 3 times as expensive. 3 times. Now technology has pulled that down. If I told you you could have that 3 times cost reduced to a normal deposition cost, why wouldn't you use a real-time solution?
That brings me to a question of sort of competence in definition, what it means to competently do whatever it is you're doing, whether it's a deposition or arguing or representing your client, managing risks. How should lawyers, whether when they manage somebody or manage themselves, should assess their competence in light of this new technology that is available to them?
Well, you know, the ABA ethical opinion, I think it's 1:1 outlines that we as attorneys need to stay up and competent on technologies. It specifically outlines, you know, kind of what that means. You need to be exploring the latest and greatest that would benefit your client. I'm old enough to remember when the fax machine was invented.
So I just got a notice from IRS and I had to fax something. And I talked to my accountant and explained that I don't have a fax machine. He informed me that nobody does it. I have to pay some internet company to fax something to IRS.
Well, you don't have a fax machine because it's obsolete, because we have email. But when we had first had fax machines, we had them because we could blast things through this wire, and all of a sudden it was printing on someone's, you know, fax machine, and we could get it done. We needed to be competent about that. Otherwise, we were going to lose business. And ultimately, if we lost a deal for a client, you're talking about, is your level of competence so bad that you're hurting the client? You shouldn't be in that case, because there's been actual litigation and case law where lawyers have been sanctioned for not. So I think depositions in the whole evolving technology around the ability to create a precise transcript at a cost that's now economical. Clients want information now. Quite frankly, I'm glad I'm at the back end of all this, because it's going to exponentially get more and more difficult.
Yeah. Of course, you also, the resistance comes in many forms, including in the form of, it's unnecessary, it's distracting to have all this happening in front of you as you're formulating questions, or, it's a lot more pressure on a witness. So you can kind of imagine different flavors of fairness and resistance arguments that are happening. Just curious your thoughts on sort of distraction, fairness.
It's very fair. The distraction piece is very fair. Some lawyers want to be eye to eye with the witness. They have their questions in their head. They don't want to be looking to the right to see how the transcript is being. Other lawyers are glued to it and using annotations, et cetera, et cetera. What I say to the people that might find it distracting, and here's how some of our clients use it. I call it the safety net use of it. Don't look at it. It's working in the background. It's working in the background. You asked for a 15-minute break. You knew you had 3 smoking guns during that round of questioning. During the break, you go back and you look, and all 3 are precise because you're a great lawyer. Or 2 out of the 3 are nowhere near precise. And you go back and clean them up. So it's more of a safety net use of it. Nevertheless, you shouldn't walk out of there not knowing that you've precisely nailed the testimony exactly how it has to be, whether it's summary judgment, or you have a mediation coming up, or you have a deposition of someone else in 2 days that might have been handling the same documents, and you already know the answers and you've nailed them down on this one. So I think that the resistance piece, it has its place as far as the use during the deposition, but I don't see an excuse for not having it if it's economical enough to have it during the deposition.
Yeah. There is a piece, though, when you depose someone, there is a human connection and chemistry that is happening that if you are more fully present, you're more likely to get to the point. So, because in the end, it is a human experience to ask someone questions, and they're not just sort of answering, because otherwise you could have done an interrogatory. You're asking somebody to look you in the eye, be recorded, possibly on video. This could be replayed. And, lying in isolation or spinning things is very different than after you build rapport or hate toward the counsel on the other side. So I definitely think it's something to think about in the best practices and maybe to experiment. The other thing I want to talk about is in-house lawyers. What I see as a trend is that in-house lawyers, and not just on sort of insurance defense, where they've historically been litigating in-house because their business is really about managing that risk. But historically, folks who may or may not even have a former litigator in-house now increasingly looking at litigation costs and risks and reputational damage that may cause, and have very honest conversations with outside counsel, use of technology, and depositions, and very early in the discovery process involvement. So I'm curious, if I'm in-house lawyers and I would like to strategically manage my destiny, whether it's cost, risk, or reputation, or whatever else, a possibility of being in front of a powerful regulator, what is that use of deposition technology that could give me advantage in managing any or all of the above?
Right. So the first thing, you're in managing risks, you obviously want to win the case. So we know that less than 1% of cases are going to trial. How are you going to win that case? You're going to win that case by discovery that shines a light on the weaknesses of the other side. You want to use everything in your bag of tricks. And now the bag of tricks isn't expensive. I think optimizing the use of technology in depositions gives you a better chance of winning that closing argument. But I do think that if you're not exploring as in-house counsel with your outside counsel, you're certainly talking about discovery budgets with them. They're not a runaway train. You want to control costs, but you also understand that the deposition process and the interrogatory process and the production of documents and grabbing all those digital files and emails, that's winning or losing your case. So you need to maximize that. That's what I would say to them.
I'll ask you to predict the future, I guess, Dean. My record is 50-50. I hope yours is higher. Where are we heading? What is this in this leverage creation and real-time insights during deposition? How can it be seen as, for example, risk, professional risk, if you use it or don't use it? How do you see this impact profession, both for law firms who actually have a shot of probably going to trial, to in-house folks who increasingly manage risks and reputational damage? What is your prediction on all that?
Yeah. So when you're using a new service or a new technology, there's certain things you need to look for, right? Is the company a SOC 2 certified company, right? Is it just AI? It shouldn't just be AI. The better services, like our service has the use of speech to text AI, but immediately human oversight, where there's someone editing the transcript while it's happening. You want to make sure that there's human oversight. You want to make sure that your transcript is admissible. You want to make sure that there's a guardian there certifying the transcript at the end of the day and making it admissible. So yes, you want to use technology. Yes, you want to maximize, but you want to make sure you choose a vendor that has all of the certifications, protects your data, and make sure that they're delivering a transcript that ultimately is admissible.
You speak about the depositions, real-time transcripts. So it was urgency. I'm just curious, from your point of view, why urgency today? Why not wait 10 years from now, maybe when AI has advanced a little bit more, maybe, after we've developed some guardrails, because as you correctly just pointed out, there's lots of sensitive information there. We're putting a lot of pressure on the witness, just by being there, with or without AI, and then you put AI, it certainly puts even more pressure. So I'm curious, kind of this technology, at least on the generative side, is fairly new and evolving, and guardrails are still to be put in place. What's the urgency of doing it quickly today, other than cost, which is not a small thing? But what else is there that makes it important to consider it today?
I would agree with you 100% that it isn't just cost, and that if you're going to do this, you make sure that you choose someone that understands those guardrails. Technology is great, but you want to make sure that there's human oversight. You want to make sure that your data is protected. So if all of those things are in place, then the sense of urgency, in my mind, is a no-brainer. It's open and shut. The guardrail question and the sense of urgency go hand in hand, and I couldn't agree more.
Well, I had a great conversation with you. Thank you so much for joining and educating us about this technology, about what to expect, how to have more leverage when you deal with conflicts, and how to responsibly look at this technology so that it's fair and not misused, and we protect constitutional rights, because those are important at the end of the day. Last question. What is one takeaway you want folks to take from this conversation?
I would say that if you're an in-house counsel, you want to make sure that when you're speaking to outside counsel, that you're using all of the tools at your disposal to maximize your ability to win cases. And as we've talked about, I truly believe that the deposition is the new trial, and that you need to maximize your efforts in all of your discovery in an economical way in order to mitigate risk and win cases.
Thank you so much, Dean. Thank you for a wonderful conversation. I thoroughly enjoyed it.
Thank you very much. Keep up the good work.
Thank you. Thank you so much. And thank you, audience, for joining. Thank you. Bye.